जय हिंद दोस्तों, फिर से आपका स्वागत है हमारे इस विजन आईएएस पीटी 365 सीरीज़ में जिसमें लोग पॉलिटी कर रहे हैं। और ये हम लोग को काफ़ी समय से इंतजार था पीटी 365 का, तो पॉलिटी आ गया और हम लोग इसे कंटिन्यू करेंगे। और इससे पहले भी हम लोगों ने कई सारे लेक्चर्स इसके बना लिए थे, तो अगर आप लोगों ने नहीं देखे तो उससे जाइए, कमेंट डिस्क्रिप्शन बॉक्स में लिंक दिया हुआ रहेगा प्लेलिस्ट का, आप लोग जाइए, इसे ज़रूर से ज़रूर देखें। और इसमें बाजीराम एंड रवि का करंट अफेयर पूरा डील किया हुआ है, तो आप लोग उसे भी देखें। और मैं यह दावा करता हूं कि आपको यहाँ पे यूपीएससी प्री के लिए इतना सारा कंटेंट मिलेगा कि आपको कहीं और देखने की ज़रूरत नहीं पड़ेगी। तो बस हमारे साथ जुड़े रहें और चैनल को सब्सक्राइब करें। अगर आप लोग हमारे चैनल पर नए हैं और अभी तक चैनल को सब्सक्राइब नहीं किया तो प्लीज़ 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 इसे सब्सक्राइब करके हमें सपोर्ट करें। कमेंट बॉक्स में आप जरूर बताएंगे कि आपको हमारी यह पहल कैसी लग रही है और आप इससे कितना लाभान्वित हो रहा है। वीडियो को ज़्यादा से ज़्यादा शेयर करें उन लोगों तक जो इस बार यूपीएससी का प्री देने वाले हैं, क्योंकि उन तक इस वीडियो को पहुंचाना बहुत ज़रूरी है, क्योंकि उनके लिए काफ़ी लाभदायक होगा और उन्हीं के लिए स्पेशली ये वीडियो बनाया जा रहा है। तो बस आपसे ये अनुरोध है कि आप हमारे चैनल को सब्सक्राइब करें, हमारे साथ जुड़े रहें। कमेंट बॉक्स में जरूर बताएं आपको हमारी यह पहल कैसी लग रही है और वीडियो को ज़्यादा से ज़्यादा शेयर करें। आइए शुरू करते हैं आज का हमारा टॉपिक, जहाँ पे हम लोगों ने पिछले वीडियो लेक्चर में छोड़ा था। तो आज हम लोग यहाँ से शुरू करने वाले हैं, यहाँ से एस्पेक्ट ऑफ इलेक्शन प्रोसेस एंड रिफॉर्म्स। तो ये न्यूज़ में क्यों आया? रिसेंटली द डिपार्टमेंट रिलेटेड पार्लियामेंट्री स्टैंडिंग कमेटी ऑन पर्सनल public grievances, law and justice tabled a report on specific aspect of election process and their reforms. फिर की एस्पेक्ट ऑफ द रिपोर्ट क्या है? तो कॉमन इलेक्टोरल रोल CER। इंडिया हैज़ टू टाइप ऑफ इलेक्टोरल रोल। पहला जनरल इलेक्टोरल रोल ओवरसीन बाई ECI एंड सेपरेट इलेक्टोरल रोल प्रिपेयर्ड बाई SEC। कॉन्स्टिट्यूशनल एंड लीगल सेफगार्ड क्या है इसके लिए? तो आर्टिकल 324 क्लॉज 1 it empowered the Election Commission of India to supervise, direct and control the preparation and revision of electoral roll for all elections to Parliament and state legislature. Article 243K and 243ZA entrust the state election commissioners with the task of overseeing the preparation and revision of electoral roll for local body election. Representation of the People Act 1950. The preparation and revision of electoral roll for parliamentary and assembly constituency are governed under the provision contained by in part 2B section 13D. False declaration during filing of nomination of election. Legal safeguard क्या है? तो candidates contesting election must file an affidavit in form 26 under the conduct of election rule 1961. Section 33A UPA under RPA 1951 require candidates to disclose information about changes framed by a court against them for offences punishable by more than 2 years imprisonment and any conviction resulting in imprisonment of 1 year or more. Section 125A of the Representation of People Act of 1951 deals with the penalties for providing false information. फिर है मिनिमम एज ऑफ वोटिंग एंड कंटेस्टिंग इलेक्शन। तो कॉन्स्टिट्यूशनल सेफगार्ड फॉर मिनिमम एज ऑफ कंटेस्टिंग इलेक्शन। आर्टिकल 84 मिनिमम 25 ईयर इन लोकसभा एंड 30 ईयर इन राज्यसभा। उसी तरह से आर्टिकल 173 मिनिमम 25 ईयर इन स्टेट लेजिस्लेटिव असेंबली एंड 30 ईयर इन लेजिस्लेटिव काउंसिल। अगला सिमुलटेनियस इलेक्शन। तो ये न्यूज़ में क्यों रहा? द गवर्नमेंट हैज सेट अप अ कमिटी अंडर former President Ramnath Kovind to examine the feasibility of simultaneous election on or one nation one election. About simultaneous election क्या है? तो aimed to synchronize the election to Lok Sabha, state assemblies, municipalities and panchayat such that voters in a particular constituency vote on the same day. It does not mean that voting across the country for all elections need to happen on a single day. It is conducted in a phase-wise manner as per the existing practice, provided voters in a particular constituency vote for both the state assembly and Lok Sabha on the same day. Simultaneous election were the norm until 1967, following the dissolution of some legislative assembly in 1968 and 1969, and the Lok Sabha in 1970. The election to state assemblies and parliament have been held separately. Later, the simultaneous election idea was proposed by the Election Commission in 1983. It was recommended by Dinesh Goswami Committee. Constitutional provision related to simultaneous election कौन कौन है? तो आर्टिकल 83 ड्यूरेशन ऑफ हाउस ऑफ पार्लियामेंट, आर्टिकल 85 सेशंस ऑफ पार्लियामेंट प्रोरोगेशन एंड डिसोल्यूशन, आर्टिकल 172 ड्यूरेशन ऑफ स्टेट लेजिस्लेचर, आर्टिकल 174 Sessions of the state legislature prorogation and dissolution. Article 356 provision in case of failure of constitutional machinery in states. नेक्स्ट इज क्रिमिनलाइजेशन ऑफ पॉलिटिक्स. तो ये क्या है? तो ये न्यूज़ में क्यों था? रिसेंटली ए रिपोर्ट टाइटल्ड एनालिसिस ऑफ सिटिंग एमपीज फ्रॉम लोकसभा एंड राज्यसभा ऑफ इंडिया 223 was released. More about news में क्या है? The report was released by the Association for Democratic Reforms ADR and National Election Watch. ADR was established in 1999 by a group of professors from the Indian Institute of Management IIT Ahmedabad. Kerala has the highest number of MPs with criminal cases, followed by Bihar and Maharashtra. Criminalization of politics. COP refers to the infiltration of criminals, lawbreakers, and corrupt individuals into the political system. लीगल सेफगार्ड इन कंटेस्ट कन्विक्टेड कैंडिडेट क्या है? तो सेक्शन 8 क्लॉज 3 ऑफ रिप्रेजेंटेशन ऑफ पीपल एक्ट 1951 says that a lawmaker sentenced to at least 2 years in jail remains disqualified for 6 years upon this release. Section 8 clause 4 of the RP Act 1951 allows convicted MP, MLA and MLC to continue in their post provided they appealed against their conviction या sentence in higher court within 3 months of the date of judgment by the trial court. In Lily Thomas versus Union of India case 2013, Supreme Court ruled this section as unconstitutional. अगला judicial pronouncement related to criminalization of politics. Union of India versus Association of Democratic Reform 2022. Supreme Court stated that electors have a fundamental right to be informed the antecedents of candidates. PUCL versus Union of India 2004. Supreme Court declared Section 33B of Representation of People Act 1951 as unconstitutional and void. The section allows candidates to furnish information only under the Act. Public Interest Foundation versus Union of India 2018. Supreme Court ordered political parties to publish the criminal record of their candidate on the website, social media handles and newspapers. Ram Babu Singh Thakur versus Sunil Arora 2020. Supreme Court directed the Election Commission to report to the Supreme Court any non-compliance by political parties. Various Committee on Criminalization of Politics. N.N. Vora Committee Report 1993 states that the nexus between the criminal gangs, police, bureaucracy and politicians have come out clearly in various parts of the country. Other commissions. National Commission to Review the Working of the Constitution 2001. Second Administrative Reform Commission 2005 etc. अगला है इलेक्टोरल फंडिंग. तो न्यूज़ में क्यों रहा ये? तो रिसेंटली द सुप्रीम कोर्ट डायरेक्टेड द इलेक्शन कमीशन टू सबमिट डाटा ऑन द इलेक्टोरल बॉन्ड्स रिसीव्ड बाय पॉलिटिकल पार्टीज टिल सितंबर 30, 2023. मोर इन न्यूज़ में क्या है? तो इन 2019 while hearing the Association for Democratic Reforms ADR petition against the electoral bond scheme, the Supreme Court asked the Election Commission of India to submit data on electoral bond received by political parties. State Bank of India has revealed that only 25 political parties have opened the bank account necessary to receive electoral bonds. Electoral bonds है क्या? तो EBs are interest-free bearer bonds of money instrument that can be purchased by companies and individuals in India from authorized branch of State Bank of India SBI. Announced in Union Budget 2017-18, sold in multiples of 1,000, 10,000, 1 lakh, 10 lakh and 1 crore. Purchased through a KYC compliant account to make donation to a political party. No cap on the number of EBs that a person or a company can purchase. Available for purchase for 10 days each in January, April, July and October. All transactions of EBs are carried out via check or digitally. The identity of donor remain confidential, reducing the risk of rationalization of intimidation for their political affiliation. Other important news में क्या क्या है? पहला है नेशनल पार्टी स्टेटस. Citing the election symbols reservation and allocation order 1968, which stipulates criteria for recognition as a national or state party, the Election Commission of India (ECI) now recognizes 6 national parties. कौन कौन सा? तो भारतीय जनता पार्टी बीजेपी, इंडियन नेशनल कांग्रेस, बहुजन समाज पार्टी बीएसपी, कम्युनिस्ट पार्टी ऑफ इंडिया सीपी, मार्क्सिस्ट नेशनल पीपुल्स पार्टी एनपीपी एंड आम आदमी पार्टी आप. हाउ इज पार्टी नेशनल स्टेटस डिक्लेयर्ड? कैसे डिक्लेयर होता है? तो वोट्स इन लोकसभा स्टेट पोल्स. A party should secure at least 6% of votes polled in 4 or more states in Lok Sabha Assembly election and in addition have at least 4 members in Lok Sabha. Seats in Lok Sabha, it should have at least 2% of total Lok Sabha seats and have candidate from not less than 3 states. Must be a state party in at least 4 states. Benefits of national party क्या क्या है? तो exclusive allotment of its reserved symbol for its candidate throughout the India. Need only one person to propose a candidate's name to file nomination. Get broadcast facility on Akashvani Doordarshan during several election. Can have up to 40 star campaigner while other can have up to 20 star campaigners. Star campaigners क्या है? तो Election Commission of India issue advisory to all star to remain within the confines of a model code of conduct. About a star campaign क्या है? तो they are nominated by political parties to campaign in each set of constituency for a specified duration. There is no law governing who can or cannot be made a star campaigner. List of a star campaigner must be communicated to Chief Election Officer and ECI within a week from election notification date under Section 77(1) of Representation of People Act RPA 1951. Recognized political party can have 40 star campaigners and an unrecognized but registered political party can have 20. Poll expenditure. As per Section 77 Clause 1 RPA 1951, they travel by air or any other mean of transport for propagating program of a political party shall not be counted as the expenditure of candidates. Freebies. Central Board of Indirect Tax and Customs CBIC issued Standard Operating Procedure SOP to limit the usage of freebies and liquor to attract voters. Freebies can be defined as offering distribution of irrational offering from political parties as part of electoral promises such as pressure cooker, washing machine, television sets, etc. free of charge. SOP aims to prevent suspicious cash, illicit liquor, drug, narcotics, freebies and smuggled good during assembly and general election. Key highlights of SOP क्या है? तो GST and custom officer to monitor the distribution of coupon based on free fuel or cash for alluring prospective voters, setting up flying squad and static surveillance team for vehicle checks and verification of warehouses, movement of items like saris, party flag, etc. associated with candidate or political party without an e-way bill may be confiscated. अगला है poll expenditure. Declaring candidate for assembly election week before poll announcement have exposed gap in election commission EC poll expenditure monitoring rule. Rules stipulated accounting of candidates spending from the date of their nomination and not from the announcement of polls. According to Section 77 Clause 1 of Representation of People Act RPA 1951, candidates are expected to keep an account of expenditure from date on which he or she has been nominated till date of declaration of results. Spreading more than maximum limit of election expenses is regarded as a corrupt practice under Section 123 Clause 6 of RPA 1951. अगला है electoral literacy. Recently, ECI signed a MOU with the Ministry of Education to bring electoral literacy to classroom across the country. Salient features of MOU क्या है? तो systematically integrating voter education and educational literacy into the curriculum, starting from class 6 to 12 in all schools. Initiative taken to promote electoral literacy. So systematic voter education and electoral participation SVEEP program, flagship program of ECI for voter education, spreading voter awareness and promoting voter literacy in India. Electoral literacy clubs ELCs set up in institute compasses across the country by ECI under SVEEP program. It is a platform to engage school students through interesting activities and sensitize them on their electoral rights and families familiarize them with electoral process on registration and voting. Electoral literacy include क्या क्या है इसमें तो information on government principal economic social and political issues that the nation is facing, the value of democracy and equal rights of women and men among others. अगला है enabling communications on real time environment EN core. Election Commission had designed in-house software for complete candidate and election management through InCore. It is an end-to-end application for returning officer to digitize the voters polled, tabulate the round-wise data, and then take out various statutory report of counting. Another application called the InCore scrutiny application. It allows returning officer to scrutinize the nomination filed by the candidate online. Through the InCore nodal app, various departments like fire, education, police, environment, etc. give no objection certificates for holding rallies, roadshow, etc. to political parties or candidates. Voter verifiable paper audit trial (VVPAT). The Election Commission of India (EC) has defended the EVM VVPAT system and termed a new petition seeking 100% data cross-verification and regressive. Rule 56D and Rule 49MA to conduct of Election Rule 1961 provide for redressal of any EVM VVPAT process verification related concern expressed by the voter. VVPAT allowed voter to see a printed slip for 7 seconds showing the serial number, name and symbol of chosen candidate. हमारा अगला टॉपिक है इंपॉर्टेंट लेजिस्लेशन एंड बिल्स. तो क्या क्या इंपॉर्टेंट लेजिस्लेशन या बिल हुआ इस पूरे 6-7-8 महीने में वो यहाँ पे दिया. तो पहला है नारी शक्ति वंदन कॉन्स्टिट्यूशन 106th अमेंडमेंट एक्ट 2023. तो ये न्यूज़ में क्यों है तो रिसेंटली पार्लियामेंट पास द कॉन्स्टिट्यूशन 106th अमेंडमेंट एक्ट 2023 टू प्रोवाइड फॉर 1/3 रिजर्वेशन ऑफ वुमेन इन लोकसभा स्टेट असेंबलीज एंड असेंबली ऑफ एनसीटी ऑफ दिल्ली. की प्रोविजन ऑफ द एक्ट क्या है तो आर्टिकल अमेंडेड आर्टिकल 239 AA रिजर्वेशन ऑफ 1/3 सीट फॉर वुमेन इन द लेजिस्लेटिव असेंबली ऑफ दिल्ली. आर्टिकल इंसर्टेड क्या है तो आर्टिकल 30A एंड आर्टिकल 332A रिजर्वेशन ऑफ 1/3 सीट फॉर वुमेन इन लोकसभा एंड स्टेट लेजिस्लेटिव असेंबली रिस्पेक्टिवली. It also includes reservation of 1/3 seat for women under seat reserved for SC/ST under Article 330 and Article 332. Article 334A. The Act provisions shall come into effect after delimitation following the first census after the commencement of the Act. Sunset clause क्या है तो reservation of seat for women shall cease to have effect after the expiration of 15 years. However, it can be extended by the Parliament by law. Periodic rotation of seat reserved for women after subsequent delimitation. The Act won't affect any representation in existing legislative assembly and Lok Sabha until their dissolution. Recently, Jammu and Kashmir Reorganization Second Amendment Act 2023 and the Government of Union Territory Amendment Act 2023 were enacted by the Parliament. They seek to reserve 33% of seats for women in Jammu and Kashmir and Pondicherry Assembly respectively. Yearly attempt to at the political empowerment of women. पहले से क्या हो रहा था तो 1992 में reservation of women in panchayat and municipalities through the 73rd and 74th amendment respectively. In 1996, 81st amendment bill was introduced to reserve 1/3 of seat for women in Lok Sabha and state assemblies. 1998 and 1999 में क्या similar attempts were made. 2008 में क्या हुआ तो the last such attempt were made in 2008 when a bill for the reservation of women was introduced and passed in Rajya Sabha. Later the bill lapsed. अगला टॉपिक है मल्टी स्टेट कोऑपरेटिव सोसाइटीज अमेंडमेंट एक्ट 2023. न्यूज़ में क्यों था द प्रेसिडेंट ऑफ इंडिया ग्रांटेड एसेट टू मल्टी स्टेट कोऑपरेटिव सोसाइटी अमेंडमेंट बिल 2022 टू अमेंड द मल्टी स्टेट कोऑपरेटिव सोसाइटी MSCS एक्ट 2002। की फीचर ऑफ द एक्ट क्या है? तो इस्टेब्लिशमेंट ऑफ कोऑपरेटिव इलेक्शन अथॉरिटी कंसिस्ट ऑफ ए चेयरपर्सन, वाइस चेयरपर्सन एंड अप टू 3 मेंबर अपॉइंटेड बाय सेंट्रल गवर्नमेंट। Amalgamation and division of cooperative societies allow cooperative societies registered under state law to merge into an existing MSCS. Cooperative Rehabilitation, Reconstruction and Development Fund to revive sick multi-state cooperative societies. Restruct- Restriction on redemption of government shareholding. Any share held by the center and the state government cannot be redeemed, redeemed without the shareholders' approval. Redressal of complaints. The central government will appoint one or more cooperative ombudsmen with territorial jurisdiction. Appeals against the direction of the ombudsman may be filed with the central registrar. Composition of board of director. The board of a multi-state cooperative society will have a maximum of 21 directors. Inclusion of पहला 1 scheduled caste and or scheduled tribe member and दूसरा 2 women members. About cooperative societies क्या है? तो it is voluntary association of individual having common needs who join hand for achievement of common economic interest. Cooperative are a state subject. The subject of cooperatives is mainly dealt with the state government and union territory administration, while with the support and guidance of the central government. Maharashtra has the highest number of 666, followed by Uttar Pradesh 168. मल्टी स्टेट कोऑपरेटिव सोसाइटी एक्ट 2002 इसमें क्या था? तो ऑब्जेक्टिव इसका क्या था? तो कंसोलिडेट लॉ रिलेटिंग टू कोऑपरेटिव सोसाइटीज सर्विंग द इंटरेस्ट ऑफ मेंबर इन मोर देन वन स्टेट टू फैसिलिटेट द वॉलंटरी फॉर्मेशन एंड डेमोक्रेटिक फंक्शनिंग ऑफ कोऑपरेटिव एज पीपल्स institutions based on self-help and mutual aid. Other developments क्या है? The cabinet has approved 3 national level MSCs under the MSC Act 2002, namely कौन कौन सा? तो नेशनल मल्टी स्टेट कोऑपरेटिव एक्सपोर्ट सोसाइटी, नेशनल मल्टी स्टेट कोऑपरेटिव ऑर्गेनिक सोसाइटी, नेशनल मल्टी स्टेट कोऑपरेटिव सीड सोसाइटी. कॉन्स्टिट्यूशनल एंड लीगल प्रोविजन रिलेटेड टू कोऑपरेटिव्स क्या क्या है? तो पहला 7th शेड्यूल कोऑपरेटिव fall in the state list of 7th schedule. Next is Article 19 Clause 1 Subclause C. States shall endeavor to promote voluntary formation, autonomous functioning, democratic control and professional management of cooperative society. Article 43B DPSP to make right to form cooperative society a fundamental right. Forming a cooperative is a fundamental right under 97th Constitutional Amendment Act 2011. Next is Part 9B. It deals with incorporation, terms of member of board and its office bearer and effective management of cooperative society. Part 9B extend from Article 243 ZH to Article 243 ZT. Multi-State Cooperative Society Act 2002. It provides for registration of societies with operation in more than one state. Next is Cinematograph Amendment Act 2023. न्यूज़ में क्यों रहा? The President of India recently granted assent to the Cinematography Amendment Act 2023. More about the news क्या है? तो it amended the Cinematograph Act 1952, enacted to make provision for certifying cinematography film for exhibition and regulating exhibitions using the cinematograph, that provide for establishing the Central Board of Film Certification CBFC for certifying film for exhibition. Such certification may be subject to modification and deletion. The board may also refuse the exhibition of the film. सेंट्रल बोर्ड ऑफ फिल्म सर्टिफिकेशन CBFC क्या है? तो पहले तो ये स्टेटरी बॉडी है. दूसरा अबाउट में क्या है? इट रेगुलेट पब्लिक एग्जीबिशन ऑफ फिल्म अंडर प्रोविजन ऑफ सिनेमेटोग्राफी एक्ट 1952. मिनिस्ट्री कौन सा? तो मिनिस्ट्री ऑफ इंफॉर्मेशन एंड ब्रॉडकास्टिंग. विजन क्या है? टू इंश्योर द गुड एंड हेल्दी entertainment in accordance with provision in Cinematography Act 1952 and Cinematography Certification Rule 1983. Composition क्या है? तो consist of non-official member as a chairman, all of whom are appointed by central government. 9 रीजनल ऑफिसेस का है तो एट मुंबई, कोलकाता, चेन्नई, बेंगलुरु, तिरुवनंतपुरम, हैदराबाद, न्यू दिल्ली, कटक एंड गुवाहाटी। की प्रोविजन ऑफ द एक्ट क्या है? तो एज बेस्ड सर्टिफिकेशन मिलता है इसमें। तो इसमें क्या डिटेल क्या है? तो एक्ट इंट्रोड्यूसेस 3 एज बेस्ड सर्टिफिकेशन अंडर यूए कैटेगरी, यूए 7+, यूए 13+, एंड यूए 16+. These age-based makers are meant for parents or guardians to consider whether their children should view such a film. They are only recommendatory category or audience certified. तो यू क्या है? यूनिवर्सल एंड विदाउट रिस्ट्रिक्शन। यू ए क्या है? विदाउट रिस्ट्रिक्शन बट सब्जेक्ट टू गाइडेंस ऑफ पेरेंट्स और गार्जियन। ए क्या है? ओनली फॉर अडल्ट। एंड एस इज ओनली फॉर मेंबर ऑफ एनी प्रोफेशन और क्लास ऑफ पेरेंट्स persons. Separate certificate for television, other media. क्या है? तो film with an A or S certificate will require a separate certificate for exhibition on television or any other media prescribed by the central government. Certificate validity क्या रहेगा? तो certificate will be perpetually valid as opposed to the present validity of 10 years. रिवर्सल पावर ऑफ सेंट्रल गवर्नमेंट क्या है? तो एक्ट ओमिट्स सेक्शन 6 क्लॉज 1 ऑफ द एक्ट एज डायरेक्टेड बाय सुप्रीम कोर्ट इन यूनियन ऑफ इंडिया वर्सेस KM Sankrappa केस 2000 which state that center cannot exercise reversal power on film already certified by the CBFC makers film piracy a punishable offense. The act prohibits the unauthorized recording and unauthorized exhibition of film and make it punishable offense under the provision of Copyright Act 1957. पेनाल्टी क्या मिलता है? तो कैटेगरीज पायरेसी एज अ क्रिमिनल ऑफेंस imposing penalties up to 3 years in prison, a fine amount of 5% of film production cost or both. अगला है OTT रेगुलेशन इन इंडिया। तो OTT क्या है? तो न्यूज़ में क्यों रहा? तो रिसेंटली डिजिटल पब्लिशर Content Grievances Council has recommended punitive action on an OTT over the top platform invoking the Information Technology Rules 2021. What is OTT? OTT होता क्या है? तो it offers viewers access to mobile television show and other media directly through the internet bypassing cable or satellite system. In India, regulatory platform OTT platform are called publishers of online curated content. Current mechanism for OTT regulation in India. Existing law में क्या है? तो certain law such as Information Technology Act 2000, Indian Penal Code 1860 and Indecent Representation of Women Prohibition Act 1986 have been made applicable to the context generated on OTT platform. Technology, Intermediary Guidelines and Digital Media Ethics Code 2021 under Section 87 Clause 2 of the Information Technology Act 2000. इट्स की प्रोविजन इंक्लूड क्या क्या इंक्लूड करता है? तो रूल्स गिव द मिनिस्ट्री ऑफ इंफॉर्मेशन एंड ब्रॉडकास्ट IB द टास्क ऑफ रेगुलेटिंग कंटेंट ऑन OTT एंड ऑनलाइन प्लेटफॉर्म। अगला कोड ऑफ एथिक्स फॉर ऑनलाइन न्यूज़ OTT प्लेटफॉर्म एंड डिजिटल मीडिया। दिस कोड ऑफ एथिक्स प्रिस्क्राइब द guidelines to be followed by OTT platform and online news and digital media entities. Self-classification of content. OTT platform would self-classify the content into 5 categories based on categories. U means universal, UA 7+, UA 13+, UA 16+, and A for adult. Patent lock. Platform would be required to implement parental lock for content classified as UA 13+ or higher and reliable age verification mechanism to content classified as A. Co-regulation approach. India's approach to OTT regulation can be termed as a light touch co-regulation model where there is self-regulation and the industry level and final oversight mechanism at the ministry level. Digital Publisher Content Grievances Council DPCGC. तो जेनेसिस इसका क्या है? सेट अप अंडर द एजेस ऑफ इंटरनेट एंड मोबाइल एसोसिएशन ऑफ इंडिया IAMAI इन 2021. मिनिस्ट्री क्या है? तो रजिस्टर्ड बाय द मिनिस्ट्री ऑफ इंफॉर्मेशन एंड ब्रॉडकास्टिंग. मैंडेट क्या है? तो इट इज़ एन ऑफिशियली रिकॉग्नाइज्ड इंडिपेंडेंट सेल्फ रेगुलेटरी बॉडी फॉर ऑनलाइन क्यूरेटेड कंटेंट प्रोवाइडर OCCP। एम क्या है? टू usher in a redressal mechanism which ensure a balance between addressing viewer complaints fairly and showcasing content without ad hoc intervention, adheres to IT Rule 2021 and such other existing of new statutes and rules relating to publishing of online curated content. COTP, cigarette and other tobacco products film rules. Under this rule, now all OTT platform has to display static message and audio-visual disclaimer on the ill effect of tobacco use. Next news is Digital Platform Data Protection Act 2023. News में क्या था? The President of India recently granted assent to the Digital Personal Data Protection Bill DPDP 2023. बैकग्राउंड क्या था इसका? तो इन 2018 सुप्रीम कोर्ट recognized privacy as a fundamental right in the case Puttaswamy versus Union of India case. Following this, the Justice Sri Krishna Committee proposed the initial draft of Personal Data Protection PDP Bill in 2018. About Digital Personal Data Protection DPDP Act 2023 क्या है? तो it aimed to regulate the processing of digital personal data and ensuring individual right to protect their data. It protects digital personal data by providing the obligation of data fiduciaries, that is, person, companies, and government entities who process data for data processing, that is, collection, storage, or any other operation and personal data. The rights and duties of data principal, that is, the person to whom the data relates. Financial penalties for breach of rights, duties, and obligations. की प्रोविजन ऑफ द एक्ट क्या है? तो स्पेसिफिकेशन एंड डिटेल है। पहला है एप्लीकेबिलिटी, प्रोसेसिंग ऑफ डिजिटल पर्सनल डाटा विद इन इंडिया इन डिजिटल फॉर्म और इन नॉन डिजिटल फॉर्म एंड डिजिटलाइज्ड सब्सिक्वेंटली, प्रोसेसिंग ऑफ पर्सनल डाटा आउटसाइड इंडिया इफ इट इज़ फॉर ऑफरिंग गुड्स और सर्विसेज इन इंडिया, डज नॉट अप्लाई टू पर्सनल डाटा processed for any personal purpose. Personal data that is made or caused to be made publicly available by data principal to whom such personal data relates or any other person who is under legal obligation to make such personal data publicly available. अगला consent. Personal data may be processed only for a lawmaker lawful purposes after obtaining the consent of data principal, who shall have the right to withdraw consent at any time. Consent will not be required for legitimate uses, including the provision of benefits or services by the government, medical emergency, etc. For a child or a person with disability, consent will be provided by the parent or legal guardian. Data Protection Board of India DPBI provides for the establishment of DPBI by the central government. Key feature of board क्या है? तो monitoring compliance and imposing penalties, directing data fiduciaries to take necessary measures in event of data breach, hearing grievances made by affected person. Board member will be appointed for 2 years and will be eligible for reappointment. Appeal against its decision will lie with the Telecom Dispute Settlement and Appellate Tribunal TDSAT. Rights and duties of data principal. Data principal will have the right to obtain information about processing, seek correction and erasure of personal data, grievance redressal, right to nominate a person to exercise rights in case of death or incapacity. Data principal must not register a false or frivolous complaint and furnish any false particulars. Violation of duties will be punishable with a penalty of up to ₹10,000. Obligation of data fiduciaries. Data fiduciary entity determine the purpose and meaning or processing must, पहला हो जाएगा ensure the accuracy and completeness of data, दूसरा हो जाएगा building responsible security safeguard to prevent a data breach, थर्ड हो जाएगा inform DPBI an affected person in the event of a breach, फोर्थ हो जाएगा इरेज personal data as soon as the purpose has been met and retention is not necessary for legal purposes. Next is significant data federacies SDF. Central government may notify any data federacy as SDF based on factors such as पहला हो जाएगा volume and sensitivity of personal data processed. दूसरा आएगा risk to the rights of data principle. थर्ड है potential impact of the sovereignty of and integrity of India. फोर्थ हो जाएगा सिक्योरिटी ऑफ द स्टेट. फिफ्थ हो जाएगा रिस्क टू इलेक्टोरल डेमोक्रेसी. सिक्स हो जाएगा पब्लिक ऑर्डर. SDF will have certain additional obligation including appointing a data protection officer and an independent data auditor and undertaking impact assessment. Next is exemptions. क्या क्या exemptions है? The rights of the data principle and obligation of data federacies except data security will not apply in specific cases including क्या क्या है? तो पहला for notified agencies in the interest of security, sovereignty, public order, etc. Next, for research, archiving or statistical purposes. Next, for startup or other notified categories of data federacies. Next, to ensure legal right and claim. Next, prevention and intervention of offenses. Next, to perform judicial or regulatory function. Next, to process in India personal data of non-residents under foreign contact. The central government may exempt certain activities in the interest of security and public order. अगला processing of personal data of children. While processing the personal data of a children, data federacy must not undertake पहला processing that is likely to cause any detrimental effect on well-being of children and tracking behavioral monitoring and targeting advisories. Next is cross-border transfer. Bill allow the transfer of personal data outside India except the countries restricted by the government. अगला penalties. Act specifies penalties for various offences such as up to 200 crore for non-fulfillment of obligations of children and rupees 250 crore for failure to take security measures to prevent data breaches. अगला है डिजिटल सर्विस एक्ट. वाई न्यूज़ में क्यों था? तो द यूरोपियन यूनियन EU हैज़ कन्फर्म्ड द नेम ऑफ 19 प्लेटफॉर्म दैट विल बी सब्जेक्ट टू इट्स ऑनलाइन कंटेंट रूल्स अंडर द डिजिटल सर्विस एक्ट DSA. अबाउट डिजिटल सर्विस एक्ट क्या है? तो DSA is the first of a kind regulatory toolbox globally and set a benchmark for a regulatory approach to online intermediaries. In 2022, DSA together with Digital Market Act DMA proposed a comprehensive framework to ensure a safer, fairer digital space will be applicable from 2024. DSA affects gatekeeper platforms like Google, Amazon and Meta and covers the need for user consent before processing personal data for targeting advertising. Difference between the EU's DSA and India's IT rule 2021. की प्रोविज़न क्या है? तो पहले इंडिया का देख लेते हैं, फिर EU का देखेंगे, यूरोपियन यूनियन का. तो इंडियाज़ IT रूल, इंफॉर्मेशन टेक्नोलॉजी रूल 2021 क्या है? तो स्कोप क्या है? अप्लाइड टू सोशल मीडिया इंटरमीडिएटरीज, डिजिटल न्यूज़ पब्लिशर एंड OTT प्लेटफॉर्म ऑपरेटिंग इन इंडिया इरिस्पेक्टिव ऑफ द कंट्री. कंटेंट मॉडरेशन क्या है? तो रूल्स रिक्वायर्ड सोशल मीडिया इंटरमीडिएटरीज टू अप्रूव ए ग्रीवांसेस ऑफिसर, a nodal officer and chief compliance officer and establish a mechanism for receiving and resolving complaints for users. यूरोपियन यूनियन का DSA क्या है? तो स्कोप क्या है इसका? तो DSA अप्लाइज टू ए वाइडर रेंज ऑफ ऑनलाइन प्लेटफॉर्म इंक्लूडिंग सोशल मीडिया, ऑनलाइन मार्केट प्लेसेज एंड क्लाउड कंप्यूटिंग सर्विसेज ऑपरेटिंग इन EU इरिस्पेक्टिव ऑफ देयर कंट्री. कंटेंट मॉडरेशन क्या है? तो DSA proposes a range of compliance requirement for online platform including content moderation measures, transparency obligation and data protection requirement. Both are similar in terms of due diligence requirement on social media platform, content regulation and co-regularity approach for monitoring compliance and grievances redressal. Next is Criminal Law Reform Act. तो ये न्यूज़ में क्या था? द प्रेसिडेंट ऑफ इंडिया ग्रांटेड असेंट to three significant bills to overhaul the country's criminal judiciary system. पहला भारतीय न्याय संहिता 2023. It replaces the Indian Penal Code IPC 1860, the principal law or criminal offence of India. बैकग्राउंड क्या था? Prior to IPC 1860, Parliament, Charter and Act East India Company Regulation, Hindu law, Muslim law, customary law, etc. Draft of Penal Code 1837 under Thomas Bington Macaulay. Effect of 1857 Rebellion. IPC was finally enacted in 1860. Post enactment of IPC 1860, several law commissioner report have recommended amendment of the IPC on subject including offence against women, food adulteration, death penalty, etc. की प्रोविजन क्या है इसमें? तो फॉर द फर्स्ट टाइम कम्युनिटी सर्विस एज वन ऑफ द पनिशमेंट फॉर पेनाल्टी ऑफेंस, इंक्रीज थ्रेशहोल्ड फॉर गैंग रेप victim to be classified as a major from 16 to 18 year of age. All criminalized sexual intercourse with a woman by deceitful means or making false promises. It removes the offense of sedition and inserted penalties penalize the following. कौन कौन सा? तो existing or attempting to excite secession, armed rebellion or subversive activities. दूसरा, encouraging feeling of separatist activity or endangering the sovereignty of or unity of and integrity of India. It defines organized crime as any continuing unlawful activity including kidnapping, extortion, contract killing and land grabbing, cybercrime, etc. Murder or grievous hurt by a group on the ground of race, caste or community, sex, place of birth, language or personal belief. Each member of such group shall be punished with death or life imprisonment and a fine in case of murder, imprisonment for a full term of up to 7 years and a fine in case of grievous hurt. अगला भारतीय नागरिक सुरक्षा संहिता, तो इसे हम अगले वीडियो लेक्चर में करेंगे। इस वीडियो लेक्चर को यहीं पर समाप्त करते हैं। उम्मीद है आपको यह वीडियो पसंद आ रहा होगा। आप लोग कमेंट बॉक्स में जरूर बताएं कि आपको हमारी यह पहल कैसी लग रही है और आप इसे कितना लाभान्वित हो रहे हैं। वीडियो को ज़्यादा से ज़्यादा शेयर करें उन लोगों तक जो इस बार का यूपीएससी प्री देने वाले हैं, क्योंकि ये उनके लिए काफ़ी लाभदायक होने वाला है। और अगर आप लोग हमारे चैनल पर नए हैं और अभी तक हमारे चैनल को सब्सक्राइब नहीं किया तो प्लीज़ 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 इसे सब्सक्राइब करके हमें सपोर्ट करें। वीडियो को ज़्यादा से ज़्यादा बार देखें ताकि आपका रिवीजन अच्छे से हो सके और आप अच्छी तैयारी कर सकें। तो मिलते हैं आपसे अगले वीडियो लेक्चर में, तब तक के लिए जय हिंद, जय भारत।